The summer is well underway, and Massachusetts is strolling towards September 1st, when massive apartment turnover grinds cities to a standstill. As a side note, for those in the greater Boston area, be careful out there on Storrow Drive and don't get your moving truck stuck. But before September, in fact, in just 3 days on August 1st, a new law will take effect changing the rules around a controversial rental practice here in the Bay State: charging renters brokers' fees. It's not quite the ban of the fees that lawmakers have been throwing around as shorthand, but it does shift the burden, in theory, from renters to landlords, unless a renter wants to secure a broker independently. I'm Jennifer Smith, and this is the Codcast, CommonWealth Beacon's podcast about policy and civic life here in Massachusetts. Today, I'm joined by Todd Kaplan, senior attorney at Greater Boston Legal Services. GBLS has been one of the groups arguing that the way Massachusetts handles brokers' fees is creating an additional hurdle for renters in an already squeezed market. So let's talk about the new legislation and whether it leaves any loopholes on the table. Welcome, Todd. Thanks for joining me.
My pleasure.
Okay, I, like many Massachusetts residents, am very familiar with the concept of brokers' fees, painfully so. But for the lucky folks who aren't, let's do a little bit of a primer first. What are brokers' fees and how do people generally encounter them?
So broker's fees are the fee that you pay the broker or somebody pays the broker to basically do the work of finding a tenant for a landlord. And oftentimes these are showing the apartment, sometimes evaluating the tenant and determining are they a good tenant, and doing some sort of a background check or a credit check. And so sometimes the actual broker does some work. And the thing that's happened in the past over the last 10 or so years is that all of the fees for paying for those brokers has shifted to tenants.
So what does that look like in practice? It's not just that when you sign on for a new apartment, you have to put down first month's rent, last month's rent, the security deposit, but there's also this additional fee that is going toward paying for the broker services, whether or not the tenant wanted them or not, right?
Absolutely. Whether the broker does any work or a lot of work, the broker is usually demanding a 1 month's fee to be paid directly to them. And that is can be theoretically negotiated, but in this market, it is never negotiated because it's a landlord's market.
So I love that you brought that up because one of the things that's been very complicated for people trying to sort of understand what was allowed before and what will not be allowed in a week, in theory, is technically speaking, brokers' fees were not required under law. Technically speaking, you could reach an agreement with a landlord that they bear the cost and you don't bear the cost. But you referred to something like a landlord's market here. So you're talking about situations in which the supply of housing is so thin that kind of in a desire to get any apartment whatsoever, or especially one that you like, you would agree to pay something whether or not you wanted it, right? Am I kind of explaining that correctly?
Yes, it is completely an imbalanced market where the tenants have no bargaining power. That is it in a nutshell.
Gotcha. So, might be a bit of a leading question, but what is the problem there really if you're thinking about brokers understanding rental markets, if they're operating well, smooth communication between renters and landlords, they're handling the tremendous amount of paperwork that comes along with moving house. So, is there a substantive problem with the idea of brokers' fees that you folks are identifying, or is it just how it's operated in practice?
So the issue here is that the broker is really working for the landlord and doing all the work for the landlord. And they go to the landlord and say, I'm gonna do this for you. Well, is that okay? I'll get paid for by the tenant. You won't incur any charges. I will find you a good tenant. Or the landlord will reach out to the broker and say, hey, I want you to be my regular person. You've been great in the past. You do all the work. Bring me a suitable tenant or two or three that I can pick from, and we'll have a good business relationship. But the problem with that is, again, the broker is working for the landlord. Now, that doesn't prohibit a tenant from going out and actually hiring a broker and saying, you bring me 5, 10 apartments. I want one of them with a swimming pool. I want a gym. That is the rare exception where somebody has a lot of money, usually is coming from out of town. They and nothing has changed. They can still contract with a broker and get all those services. But the real problem here has been that the broker has been working for the landlord and the tenant has been paying for it.
So that's a great point because the governor has been calling recent legislation that we're talking about here a ban on brokers' fees, or at least it's being shorthanded into that right now. And so is that accurate, or to what extent is that oversimplifying?
That is oversimplifying. I think in the vast majority of cases, the if a broker continues to be involved, they will be paid for by the landlord. But this law does not prohibit a tenant from engaging a broker. And it's just the few people. Again, the biotech person coming from out of town, the Harvard professor who's going to be here for a semester, they can always go and hire a broker. And they should, because they want have very particular needs. The rest of us need to find housing, and if the broker is working for the landlord, really the landlord should pay.
And so some real estate groups are saying that the law that takes effect soon only changes how the costs land on renters. Of course, the argument there being that a landlord is still possibly going to adjust rents to cover these brokers' fees. Now, my understanding is that is not legal to begin with.
Well, you know, you raise a very good question, which is whether if you disguise it as another fee, is you disguise it as a like a service charge or a garbage fee or something like that. You're being tricky and just adding it in to a ongoing fee. Is that legal? And I would argue that it violates the spirit of the law, but I want to be straight here. The market is the thing that governs what a tenant is going to pay. So landlords have and continue to raise rents, and they do it as much as they can, unless they're the rare ethical landlord that is trying to moderate the market. But most landlords are saying, I'm going to get as much rent as I can. And this doesn't stop them from trying to raise the rents. But the market is the thing that's going to determine whether they can actually do that. And so they could, let's say, for example, the rent was 3,000, now it's 3,050 per month. And over a year, they recoup $600 or whatever. Maybe they raise it 100 and they recoup $1,200. That could help pay for that fee for them, but they really can't do that if the market won't allow it. And so that's the real bottom line. I mean, we have seen, and I did want to mention, we have seen some in the past efforts for what we call junk fees from landlords, where the landlord says, I'm now going to charge you for putting out the trash. I'm now going to charge you for cleaning the halls. I'm now going to charge you for washing the windows, or whatever they want to charge you for that they were providing as part of the services in the past. Um, some of those might be legal, some of those might be illegal, but landlords will, like a lot of businesses, as we've seen, like for example in the airline industry, try to nickel and dime you into paying more willy nilly any way they can.
I'm glad you brought up these sort of additional fees right now because there is another question about what you can or can't be on the hook for in terms of a rental agreement before the state's high court right now, which is how they handle dispensing with the security deposit, because Massachusetts has some very strict laws around what you can and can't take out of the security deposit, what counts as sort of ordinary wear and tear, which legally you're not supposed to be able to take out of someone's security deposit. You know, you can't penalize someone for living in a house that is meant to be lived in. But the question about whether you can kind of agree to contract with your tenant into saying, sure, I'll do a kind of de facto deep cleaning of the rugs and you can take that out of the security deposit. All of that is an aside, but that's the sort of thing that is kind of part of this broader picture right now as Massachusetts struggles with its housing crunch. And part of that, of course, is to do with how much it costs to live in Massachusetts. That is an aside. I will ask, though, did the language that the legislature ended up on feel like the ideal language for you around the broker's fees? Because it does seem like there's a bit of confusion over what is and isn't illegal or what just is or isn't frowned upon.
Actually, I think they did a good job because there was a governor's version, there was the House version, and then there was Senate version. And Senator Edwards put forth an amendment to even improve the Senate version, and that was adopted by the Senate, and that was the final version that is now law. And the original language coming out of the Senate said basically a landlord can't charge more than these set fees, which are the usual ones. That we've always thought that it was illegal for a landlord to charge brokers fees, but they got around it by having the broker contract separately with the tenant. But it was kind of a little bit ambiguous, and so the additional amendment from Senator Edwards says, hey, whoever contacts the broker first should pay. And that really codifies what is the practice, what really happens in the real world, which is that, as I said before, the broker will go to a landlord and say, hey, I see you're got a listing here on Craigslist. Hey, take that down. I will do all the work for you. I'll take all the hassle out of this. I'll bring you two or three or four qualified tenants. You get to pick and choose. And that is the way it's worked in the past. The broker has gone to the landlord and said, hey, don't, I'll take all the hassle out of this. I'll bring you some good people and you won't have to you won't have to deal with them until the final decision. I'll drop the lease. I'll do all the money. I'll do everything for you. And that is really, or the landlord, as will have a go-to person or go-to firm. Hey, you guys have done a great job in the past. You can continue to bring me tenants. And the broker does all that work. So that was kind of the de facto arrangement, but the law makes it 100% clear. Whoever contacts the broker first, and again, it's 99% of the time, it's going to be a landlord reaching out to the broker, a broker reaching out to the landlord. They have a relationship. They may not have a written contract, but because they have that understanding, it's clear that the tenant is not going to be on the hook.
And how did this actually become a priority for Greater Boston Legal Services? You know, there's the whole universe of ways in which people interact with housing that can be difficult to process or cause a certain amount of agita in either the renter or the landlord or both of them. So, why this subject?
Well, it's not just low income people who are our primary clients and elders that are affected by this, but our clients are especially affected because this has greatly diminished people's ability to get better housing. So if you're in crappy housing and your landlord is not taking care of it and you just want to move, up until now, you had to put up four times first, last security and a broker's fees. That broker's fee, that could be a lot of money. That could be $12,000 that you have to accumulate up front. So that for a lot of our clients was an insurmountable hurdle and actually impaired people to get to better housing, better neighborhoods, or even get away from a landlord that's not doing a good job. So it really, really affected our clients because they don't have the resources. They don't have the cousin, the relative, the friend that can loan them the money to let them move. Um, One of the hardest thing about being poor is being poor. So that really was a huge burden on our clients, and it's they still have huge issues in this market. This is a crazy, terrible market, but it has chipped away at one hurdle.
So, walk me through the hypothetical here. What would it look like if someone started the rental process today, which is still in July, versus in a week? Let's say you're trying to figure out how to close. How does it look different now versus in just a few days?
Well, I actually have friends that have been waiting to move till this law comes in effect. I've been telling it it's going to happen because there was a huge amount of momentum behind this. The governor was behind this, the House was behind this, the Senate. So we knew something was going to move. Whether it was as good it is, we didn't know, but we were really knew that something was going to happen. So the difference really is that in July, you approach that broker could probably demand that you pay the broker's fee. Starting August 1st, when you approach that broker, you can say to the broker, hey, do you have a relationship with this landlord? And if that broker is honest and they have a license and they're supposed to be honest, and they say, hey, yeah, I've been working with this landlord, then that landlord is on the hook for that fee. If you go to a broker and you're just like, the brokers often will put things on Craigslist to just to hook you in, reel you in, say, oh, I'm sorry, that apartment's not available. Look at all these other ones I've got that are great that might need your fee, meet your needs. And you say, okay, well, I'll work with you. And the broker says, well, I actually have a fee, and here's my fee. And again, if you decide that you want to pay that broker, you could theoretically do that. But the broker really should be. I think the question really is on, unfortunately, on the tenth to under the new law. And here's how we said it on our flyer that we're posting on our internet. Either a landlord or tenant can hire a broker. Tenants should check if the broker works for the landlord before agreeing to pay any fees to the broker. And so that's a little bit pushing the edge that you have to be a little bit. But a broker's, they're on the line for their license is in jeopardy if they lie to you about that.
Well, that does sort of raise one of the other questions or critiques here that I've seen around this, which is basically, are we dealing with a letter of the law issue or an enforcement issue? And of course, those overlap with each other, but if it's kind of coming down to honor systems, if it's kind of coming down to this really, really tight market, I guess, how likely is it? I know you wouldn't have an exact number here, but how likely is it that we would still see kind of some of these dynamics playing out in practice?
I agree with you that there are going to be brokers out there that are still going to try and push the fees on to the tenants. But I think that we're going to see a dramatic shift in the market in general. The Attorney General has pledged to support this law and enforce it. They have a very, very good consumer advocacy and resource division, which their number is 617-727-8400. They are happy to um, follow up on complaints. And I think for this Attorney General, it's a priority to ensure that this law is enforced and upheld.
And you mentioned earlier different types of landlords, of course. So, one thing that comes to mind is how do you anticipate this change impacting different types of landlords? So, you've got everything from kind of the very large commercial landlords to someone who just has an extra room or extra apartment space in an owner occupied building in Boston. Was there any thought about this kind of impacting them differently because landlords, like tenants, are also differently resourced?
The law really is one size fits all. But I think it will have a different impact on different markets. What we've seen in the larger management companies is that they're not using really brokers at all. They're using automated systems, they're using online systems, they're using tenant screening services, they are using algorithms or computerized systems to determine who qualifies as a tenant. So it's much, much less of using the broker system. But that is likely not the majority of the market. The majority of the market is likely still going to be smaller landlords that are still using brokers. And then there's some landlords that don't even use brokers at all. You can still apply directly with the landlord. I was helping a tenant yesterday, and we looked up a listing on Craigslist, and it said, apply directly with me, no broker, no broker's fee. So there are still people out there that are doing their own screening.
And so we're talking today on July 24th, which is a day after the Small Property Owners Association pulled together a mix of landlords, brokers, real estate agents, because they're lobbying to delay the new law. And the arguments, we've talked about a bit of them before, but the primary one is that this is essentially just changing the way that costs end up passed along to renters, and then saying that the language of the law is likely to open it up to lawsuits. How do these arguments strike you? We've kind of gotten into the weeds on them, but does that seem to be kind of an on its face good faith objection?
I don't think there's any ambiguity in the law. I don't think there's going to be any um, problem in implementing this law. I think a last ditch effort by a few to undermine this law is not going to be successful. This had incredible widespread support. It was a part of the budget, which is a very, very fast vehicle for getting something done. It was a priority for the governor, for the House, for the Senate. I don't see any way they're going to roll this back.
And can you help me clarify? I think it's helpful sometimes what's actually going into effect on August 1st, because plenty of folks are heading to a September 1 lease start. We know the September 1 date in Boston is kind of the big turnover and also is in a lot of these college towns. Many folks already signed the contracts back in April or May or earlier, if I recall correctly from my college days here in the Boston area. Those would not be impacted, right? This isn't a retroactive, you can go back and kind of shake your fist at a broker, right?
Yeah, I agree with you that if you have a valid contract with a broker, in fact, the brokers regulations say that when a broker wants to get paid, they have to give you a document saying, I am working for you, and the broker signs it and then gives it to the tenant. And then, so that should have happened way back at the inception of their relationship, even before the broker started doing anything for the tenant. So I think that they have a good argument that that is an enforceable contract, and that the change in the law doesn't really it's not going to have any retroactive effect.
And so I guess this takes us to the sort of forward looking portion here, which is you've mentioned, and we've both kind of talked about a few other ways that there can be barriers to accessing housing that have to do with costs, that have to do with resources. Uh, if you are kind of confident that there's basically no chance, given the bulk of support around this on Beacon Hill, that the brokers' fees alterations are going to be tossed, do you hope to see any alteration to the language itself, or what do you hope to see legislators take up next on the subject of housing accessibility?
So, what is pending at the state house right now are several bills that address what we call junk fees. And here's some junk fees that landlords are imposing. For example, one roommate is moving out, another roommate is moving in, and the landlord wants to charge a whole month's rent to screen one tenant, which honestly is going to take them 5 minutes. They might pull a credit report, something like that. So that is really gouging people. The other things that are we're seeing is, for example, requiring a tenant to use a particular payment system to pay the rent that charges a fee. So the landlord doesn't have to handle checks or cash or collect rents. And that, we think, is probably potentially illegal, but should be clarified that that is wrong and illegal, because again, it's just passing along a expense from the landlord to the tenant, which is accounting for and collection of money. Um, there's so many other ways that landlords are trying to nickel and dime tenants, and those junk fee bills will address that, those issues, which really are hurting, especially low income people who are barely able to pay the rent in this market.
And I guess the last thing, which is from your perspective, where are the landlords in this equation? There's been kind of complaint that this will essentially throw the industry into turmoil as folks try and interpret the law and figure out what to do with the people that are trying to skirt it. I expect there will be pushback around kind of those fee structures as well. So, are there landlords that, in your experience, have been supportive of this change to the broker's fee structure, or is it all been kind of at best an arm's length relationship?
There are certainly lots of landlords that don't really quibble with this change in law because they understand that the broker is working for them. I'm a landlord. I have a one bedroom unit. We have a great tenant right now. I know that if I have an expense, I can deduct it on my federal and state taxes because that's a legitimate expense that goes to how I have to run my that pay for that apartment. So when landlords are de- really saying that they are hurting, that is belied by two things. One is that the market has been increasing rents, and their expenses have not been anywhere increasing at the same rate as their ability to charge more rent. So there's no question about that. And the second, of course, as I said, is that they can deduct expenses, and this is just one other expense. It's not even a lot, and you know it a good landlord can keep a tenant for many years, and this once in a while they might have to pay a broker's fee.
All right, Todd. Well, thank you so much for joining me.
It's been my pleasure.
Thanks again to Todd Kaplan for joining me on the Codcast. Thank you for listening. I'm Jennifer Smith. Our producer is Charlie Cazella. Leave a rating and review wherever you're hearing this now if you want to help other people find us, and email codcast@commonwealthbeacon.org if you ever want to get in touch directly. We will be back in your ears next week.